Hello, how are you? In this video, I will present the research results obtained in the master's program at the University of São Paulo. The research topic is Jurimetrics applied to banking lawsuits. So, let's get started. What is this research about? This pertains to the automated extraction of data from lawsuits on the São Paulo State Court of Justice website, Brazil. From this, a statistical analysis of banking lawsuits within the state's jurisdiction is conducted. The data pertains to cases adjudicated in 2019 involving Santander, Bradesco, and Itaú banks. In the lawsuits settled in 2019, banks were defendants in 70% of the cases, while they were plaintiffs in only 30%. In other words, banks were more often the defendants than the plaintiffs. Among the banks examined, Bradesco Bank had the highest number of lawsuits adjudicated. Santander Bank holds the record for the highest proportion of lawsuits, where they were the defendant, at 78%. On the other hand, Bradesco Bank tops the list when it comes to the highest proportion of lawsuits, where they were the plaintiff, at 36%. These are the types of lawsuits involving the banks as plaintiffs. The types of lawsuits highlighted in yellow indicate that the three banks utilize the judicial system for asset collection and recovery purposes. Nearly 59% of the lawsuits involve some form of debt collection and asset constraint. In other words, when filing lawsuits, banks essentially use the judiciary for debt collection and asset recovery. Here we can observe the most frequent subjects in lawsuits filed by banks. Banking contracts are at the forefront of civil lawsuits filed by banks, making up 67% of the cases. The most common types of these contracts include fiduciary alienation, which is similar to chattel mortgage, as well as credit cards and insurance. However, when banks find themselves as defendants, the most common issues revolve around civil liability, accounting for 27% of the cases, and in-kind consumer contracts, making up 23% of the lawsuits filed against the banks. We conducted a comparison between the total economic value of banking lawsuits and Brazil's GDP in 2019. Interestingly, the 36,000 lawsuits where banks were the plaintiffs accounted for a larger economic value, representing 9.8% of the GDP, compared to the 82,000 lawsuits in which the banks appear as defendants, amounting to just 8.6% of Brazil's GDP for that period. In other words, the lawsuits in which the banks are defendants are more numerous, but have a lower economic value. Interestingly, despite being fewer in number, lawsuits initiated by banks take over twice as long, about 34 months, to reach a court decision. This is in stark contrast to those filed by consumers, which typically conclude in just 15 months. Therefore, we can conclude that when banks are plaintiffs, lawsuits have a higher economic value and take longer to reach judicial judgment. Here we can identify a spot for future research. Is there a correlation between the economic value of civil lawsuits, the duration of litigation, and the outcomes of judicial decisions? Does a higher economic value suggest an extended duration of civil litigation? For instance, this is a field for future investigations. Now let's specifically analyze the lawsuits whose main subject is banking contracts. We identified the types of lawsuits involving banking contracts. When it comes to banking contracts, banks primarily use the judiciary to enforce these contracts, accounting for 58% of the lawsuits filed by banks with this subject matter. On the other hand, consumers predominantly seek judicial intervention for the revision of contractual clauses, representing 80% of the lawsuits related to banking contracts filed against the banks. The judgment's outcomes regarding banking contracts were analyzed, considering all existing types of proceedings. In 52% of cases, consumers have some legitimate right when filing lawsuits over the subject matter of banking contracts, considering full and partial success and self-composition in all types of judicial procedures. Analyzing the outcomes of judgments on the subject of banking contracts, it is possible to verify that the small claims procedures result in more favorable court decisions for consumers than the civil ordinary procedures. Despite this, consumers have shown a preference for civil ordinary procedures when filing lawsuits against the banks. Here is an extract of a lawsuit consultation obtained from the São Paulo State Court of Justice website. This website was utilized as the primary source for the extraction of research data. The data from the lawsuits was automatically extracted and transferred to a database. Using the collected data, we have generated a set of statistical indicators accessible via the QR code displayed on the screen. This dashboard allows to analyze the number of lawsuits per banking institution and their geographical distribution in the state of São Paulo, Brazil, the procedural roles assumed by each bank in these lawsuits, the judgment outcomes associated with each subject matter, type of lawsuit and bank, the distribution of lawsuits by value range, and the statistics regarding the economic value and processing time of lawsuits categorized by lawsuit type and legal matter involving each bank. It is important to clarify the scope of the research. The data pertains to the São Paulo State Court of Justice, considered the world's largest court in terms of number of lawsuits. The analyzed lawsuits are of a non-criminal nature and refer to cases already adjudicated at the first instance involving Bradesco, Itaú, and Santander banks during the period of 2019. The research universe corresponds to 119,000 lawsuits. These are the main results achieved in the scientific research we conducted during the master's program at the University of São Paulo. We cordially invite you to access the online dashboard for statistical analysis of lawsuits. We greatly value your attention and time spent on this matter. Thank you.